Welcome to Renters' Rights Radio.
Welcome back to Renters' Rights Radio with attorney Debi Rumph, founder of the law offices of Debi Rumph. Now, Debi focuses on Florida tenant law and works with renters and families across the state to help them understand the real legal and financial risks hidden inside lease agreements. I'm Evan Mack, and today we're talking to parents. If you co-sign your child's student lease, do you actually know what you agreed to? Most families find out way too late, and Debi breaks down exactly what's at stake. Miss Debi, my dear, welcome back.
Thank you, Evan.
So Debi, when a parent signs as a guarantor or a co-signer on a student lease, what legal role are they actually stepping into?
That's a great question. And it depends. It really depends. On the prior episode, we talked about the two types of roommate leases. We talked about the traditional joint roommate lease, and we talked about the single student lease. That type of lease has evolved in the last 25 years or so. So the parent responsibility when they co-sign the lease is going to greatly depend on what type of lease their student signed. And so this is probably a little bit more controversial when we're talking about the joint traditional roommate lease. So I will focus on that. Okay. When a parent co-signs that type of lease, they're stepping into the shoes of every single tenant that lives in that rental home. If the rent isn't paid, they pay all of the rent. The whole entire rental obligation is on the parent. If someone breaks the rules and there is a breach of that lease, the parent again is stepping into that role and is guaranteeing the payment of all of the remaining rent that may be left on the lease.
So how is a guarantor's liability different from the student's tenant liability under the lease? The no notice or, anything like that?
You hit the nail on the head. Notice is huge. Now, in traditional, and no matter what type of lease agreement a student may enter into, or even a non-student, under Florida law, if the landlord has something to complain about, whether that's failing to pay the rent or there's a breaking of the rules, the law requires the landlord to provide the tenant with not only notice of what the landlord is complaining of, but also an opportunity to correct the situation. We call that an opportunity to cure. A guarantor usually, and most of the guarantor agreements I've seen, the guarantor, the parent, doesn't get that same notice or opportunity to cure. So that's huge. A lot of times when parents contact me, their credit has been impacted, evictions have been filed before they've even had a chance to know that there was a problem or to correct the problem. That's number one. Number two is renewal of leases. As you can imagine, there are leases that will automatically renew. Florida law gives the tenant notice your lease is going to renew. Remember, if you're not going to renew your lease, these are the certain things that you need to do so that the lease is not renewed on you and additional rent obligations do not accrue on you. Guarantors do not get that same notice. So that is how it is very different being a guarantor as opposed to the actual tenant. So hopefully students are talking to their parents, but that's not always the case in my practice.
So are the guarantors typically responsible only for unpaid rent, or can their exposure extend to fees, damages, legal costs, and other charges?
Well, it depends again. It really depends on that guarantor agreement. I want to be clear. The parents, when they guarantee a lease, they have a guarantor agreement and a lease. So they have to read the lease, understand what they're agreeing to under the lease, and then they have a separate agreement called the guarantor agreement. So most guarantor agreements are written by landlords or their attorneys. And so, as you can imagine, I've never seen a guarantor agreement that did not cover each and every penny that a landlord is entitled to under the lease, whether that's late fees, administration fees, attorney fees, court costs, etc. So parents are signing up for everything that could be awardable under that lease.
So is this even with, no advance notice or right to cure at all?
That's absolutely with no advance notice or right to cure. And a lot of landlords get parents to agree to that in the guarantor agreement.
In a joint and several liability structure, how does the guarantor's exposure expand if one roommate defaults?
So again, it's going to depend on the type of roommate lease that was signed. Do we have a joint traditional roommate lease or do we have a single roommate lease? If we have a single roommate lease, the joint and several liability will not apply. However, if we do have joint and several liability, the parent is on the hook for everybody's rent, even if that is not their child and even if they didn't have notice.
Can a parent end up responsible for the actions of roommates if they've never met?
Absolutely. And in fact, that's typically the case, right? They haven't met the roommates, but they're on the hook. It doesn't matter, who failed to pay. If we're in a traditional roommate situation, the parents are on the hook.
Wait, what can parents do to avoid this type of liability?
So the first thing is to negotiate their guarantor agreement, right? Like don't sign a guarantor agreement where you're agreeing to, you know, uh guarantee all of the rent for all of the roommates. If it were me, I would attempt to negotiate a single roommate lease for the tenants. That way, if one person defaults, that's between the landlord and that tenant, and not necessarily my child or student. But if the landlord is unwilling to negotiate a single roommate agreement, I would highly recommend trying to find some place that would. But if not, and you find yourself stuck, certainly try to negotiate the terms of the guarantor agreement where you are entitled to notice of any late rent payments before a 3-day notice is issued, and that the landlord is keeping you apprised of what is going on and will cooperate with you if you do find yourself in a situation where you need the landlord's cooperation.
Hmm. Does the guarantor's obligation automatically end if the student transfers, withdraws, or maybe even studies abroad?
No. And this shocks so many students and parents. Absolutely not. The
Wow.
only thing that's going to turn off that obligation to guarantee is a termination of the lease. A lease must be terminated before the guarantor obligation goes away. And in fact, a lot of people believe, one common scenario is when students are in school and then they're suspended from school or they have to take a semester off, and they think that's a reason for the lease to be turned off. It's not. If you didn't negotiate that as a part of your lease agreement, you're not being in school does not impact the obligations under the lease and certainly will not impact the guarantor's obligations under the guarantee. So these are things, if you think that they're going to be an issue, you would want the landlord to do an addendum or negotiate those terms ahead of time. But certainly, if one of these things happened to you before you inform the landlord that this happened to you, I would highly recommend you try to find a reason to terminate the lease on different grounds to get from under the lease. That way, once the lease is terminated, the guarantee is terminated as well.
Mm. How does that early termination clause, interact with guarantor or liability?
So early termination clauses should impact the guarantor's liability by limiting the liability if there is no other legal way to terminate the lease. So I presume you're asking about the early termination clause. If I decide I want to terminate early, I could pay this fee and be done. I would highly recommend, if a tenant takes that approach, to negotiate a termination of the guarantee along with the termination of the lease. So it will cut off the guarantor's liability, but I wouldn't assume that. I would negotiate a termination of the lease, get that in writing, and say that the guarantee agreement has been fully satisfied with the payment of the early termination fees.
Does that mean hand in hand as well?
Yes, they should go hand in hand. If a parent guarantees a lease and there's any termination or any expiration of the lease, the guarantor and the tenant should be working hand in hand in order to make sure that that lease is fully terminated and that the liability under the guarantee has been satisfied.
Mm. So if a landlord pursues collection, what remedies are typically available against a guarantor and how quickly can that escalate for people?
The biggest weapon that a landlord has against a guarantor is the fear of damaging the guarantor's credit. If you think about it, the reason the guarantor is the guarantor is because that guarantor has good credit. They pay their obligations, they pay their bills, they're credit worthy. The leverage the landlord has is, I'm going to do significant damage to your credit if you don't pay me. And so, even in the most unfairest of situations, we've had clients decide to pay in order to protect their credit worthiness because that's important to them. And so that's the biggest weapon the landlord has, and they use it very well.
Hmm. What leverage do debt collectors, generally have against guarantors in these type of situations?
The same thing, the credit and dragging people into an eviction. An eviction process is a very public process, and people can look up your name and see that you've been in an eviction action. So landlords use that leverage and they use the credit leverage as well. And also the guarantor agreement is very pro landlord, and they use that to their advantage as well.
Hmm. So before signing, what specific provisions should parents review carefully to understand, the true scope and duration of their obligation?
The first thing that they should review is the lease agreement, because that's going to be the basis of the guarantor agreement. When the landlord puts the guarantor agreement in front of the parents, that guarantor agreement is going to say you are guaranteeing performance under this lease. So the parent actually has two contracts they're navigating. So the first thing I would say as a parent is I want to know, am I signing or am I guaranteeing a traditional joint roommate lease or am I guaranteeing a single roommate lease? That's going to be crucial. Number two, I want to know who and what am I guaranteeing? Well, I'm going to have to fully understand that lease agreement to know what I am guaranteeing. And I'm going to have to review that lease agreement to see who I am guaranteeing. Number three, what are the notice provisions? What notices are you agreeing to give to the tenants? What notices are you willing to give me? How much opportunity am I going to have to resolve this before you leverage my credit, before you drag me into a court proceeding? Those are the main things that I, as a parent, looked at when my daughter signed her lease and we guaranteed her lease.
Mm. So what is more important though? What they're guaranteeing, the notice provisions, or the right to cure provisions.
Who and what you are guaranteeing. Again, it goes back to, am I working with a traditional joint roommate lease? That is a significant undertaking. And it's a very different undertaking if you were guaranteeing a single roommate lease. Under the joint, you're guaranteeing everybody. And I have a small story about that. Um I had a parent who guaranteed a traditional joint roommate lease. Unbeknownst to her, she was on the hook for everything. One tenant did not pay. It was one of these, four roommates in an apartment. One tenant stops paying, and I have to give her the news, hey, to stop this eviction from coming down on you and to stop the credit until we come up with a strategic solution to get you out of this, you're going to have to pay that rent. We have to stop the landlord so we could go back and strategize with the tenants to try to terminate this lease and get everybody out of here. Well, one tenant saw, hey, I'm not paying my rent and I'm staying, so she shared that with other roommates. And then the other roommate stopped paying. Well, if her mom has it, then why are we paying rent? She's staying rent free. So then you have this parent who's carrying the entire load. So the well was poisoned and everybody else stopped paying, and so she was the only one paying until we strategized that the termination of lease.
But so, Ms. Debbie, if a parent has already signed and is concerned about exposure, what proactive steps can, help limit that risk going forward?
Just like we did in that particular situation, we strategized a termination of that lease. We strategized and It was one of the most challenging roommate situations that I have been in. In fact, one of the most rewarding cases was getting those parents from up under that situation. So I always go to strategize a lease termination. Don't say anything to the landlord because that will, give the landlord potentially some defenses, but start strategizing a way out of there. And that's primarily lease terminations or assignments and subletting.
Wow. Miss Debbie, thank you so much for your time.
It's my pleasure.
All right. That wraps up today's episode of Renters' Rights Radio with attorney Debi Rumph. If you're a parent reviewing a student lease or already signed as a guarantor and want clarity about your financial exposure, visit debirumph.com/lease-termination/options to explore Debi's unbundled legal services and get guidance tailored to your situation. Don't forget to like, subscribe, and leave a review so more Florida renters and families can better understand their rights. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.